State versus Smith looks at an application of what we saw in State Rule 616, and I'm calling it State Rule 616 because this is a rule that a number of states have that really does embody much of the uncodified interpretation of the federal rules of evidence. And the key thing to take away from that, other than the fact that it clearly lays out that for bias and misperception, you can offer extrinsic evidence to show the witness's bias or misperception, like the strength of my glasses. You could offer the prescription to show how very strong my glasses are, and they really are. But for statements that show contradiction, either the prior inconsistent statements of the witness or the statements of this witness that conflict with other witnesses, courts have said, and many states have codified with that Rule 616, that you can only bring in those contradictions as extrinsic evidence that go to the heart of the matter. You can always say to the witness, didn't you tell your dry cleaner that the carpeting was brown rather than blue? But we can only bring in the dry cleaner to actually say you said the carpet was brown rather than blue if the color of the carpet actually is a material relevant fact in the case. So in State versus Smith, we've got yet another case where the defendant claims he accidentally shot his wife with a shotgun. This is probably our third case that has this set of facts. I don't know why this particular fact pattern continues to give us such great evidentiary decisions, but it does, at least in nice little tight compact packages that are very easy to explain. So in this case, the detective interrogated the defendant at the hospital, or at least spoke with him. And there, according to the detective at the trial, the defendant never said that the shooting was accidental. But the detective, at least according to someone from the public defender's office, the detective had spoken to someone from the public defender's office and told the detective told the public defender that the defendant had said the shooting was an accident. So when the witness is on the stand, the defense lawyer says, did the defendant ever say that the shooting was an accident? And the officer said, no, he never said that. Well, now, officer, didn't you tell someone that the defendant said that the shooting was an accident? And the officer said, oh, no, I never told anyone that. So the defense lawyer wants to bring on the person from the public defender's staff who will testify that, in fact, the officer just said or had said what he now denies saying. And the question then becomes, is that statement collateral, or is that statement relevant and material to the case? So the court in Smith goes through the rationale for rendering that decision. And it's not like a really neat test, or a clean test that you can apply the elements of. But what the court says is what we really are trying to do with this rule is not waste our time with something that's not directly relevant to the case. If the witness is saying different things, then if the witness is saying different things at different times, or if the witness is saying different things than other witnesses are saying, then we get to bring in those witnesses to the extent the witness is talking about things that are at the heart of this issue or just simply relevant to this issue. Because the rest is sort of like, if you couldn't independently bring in that information, then if that information is not independently relevant, then the fact that the witness is wrong about it it doesn't really tell us that much. The witness wouldn't have necessarily tried to, jog his memory before coming to court about all the details that really aren't that central to the case. And the fact that he might be wrong about details that aren't central to the case or aren't relevant to the case really tells us very little about this witness's credibility. But if the witness is wrong about things that are central and are at the core of the case, then that actually tells us something pretty important about this particular witness. So if in fact the witness, here the detective, is representing to the court that the defendant never explained that this shooting was an accident, that's something big, because that's not something you would forget. That would be inconsistent with this prosecution. Now, clearly, the defendant has a reason to mitigate his own involvement, to explain away his innocence, or to explain his innocence. We're not saying that the defendant's statement is, pure, that it's unmotivated by any, just need to fabricate. The defendant has a strong bias. But if the detective is hiding from the jury the fact that the witness said it was an accident, then maybe the detective has a bias as well. Maybe the detective is shading the rest of the evidence. That the fact the defendant said it was an accident is certainly something worth the jury's considering. That statement is hearsay, but that's something worth the jury's hearing, if there's a hearsay exception that gets that statement to the jury. So the court says that this statement is very much at the core of the operating facts. And therefore, if the detective denies that he said this, and someone can testify that he did, this really is at the core of what we're trying to get at. This is something that is highly relevant to an investigation of this matter. And the fact that the officer is wrong about this is not some collateral issue that would have limited ability for us to understand problems with the witness's testimony. This goes to an issue that we would expect the detective to get right, and the fact the detective is perhaps getting it wrong, if you believe the person from the public defender's office, may well tell us a lot about the detective, because the issue is so central to a homicide prosecution where the defendant will claim that it was an accident. So this is the rule. You cannot bring in collateral issues through extrinsic evidence. You can always ask the officer, didn't you tell someone that the carpet was blue? And if he says no, that's the end of the story. But when you ask the officer about something central, didn't you say this? And if that issue is central to the case and he denies it, you can bring in the witness who heard him say something to the contrary.